All right. Well, I know you guys are all as happy to be here as I am. My name's Lauren Goldberg, and I'm actually the managing attorney at KP Law, which represents about 130 cities and towns in Massachusetts. Before I came to the firm, I was a staff attorney in the Public Records Division of the Secretary of the Commonwealth's office, and then I was legal counsel to the Elections Office. So I've been dealing with public records and open meeting law for the entirety of my career. And then they chose to rewrite those laws because I was getting a little bored of them. So now they're a little bit different. All right, just so I have an idea, excuse me, maybe you guys raise your hand if you're on a land use board. Land use board? Okay. How about CONSCOM? Okay. See, sometimes people don't want to raise their hands to land use when they're on the CONSCOM. All right, what about Board of Health? Okay. Where else? What am I missing?
Council on Aging.
Council on Aging.
Ability assistance.
Okay.
Cable advisory.
Okay.
Affordable.
Youth Center Board.
Okay.
Historical.
Okay.
Library Board of Trustees.
What'd you say?
Community preservation.
Okay. All right. So some of what I'm going to talk about is going to be directed to land use boards in terms of what they put on their agendas. But it's useful no matter what kind of capacity that you're serving in. Okay, so this is a disclosure because I'm a lawyer. You don't need to read it right now, but go back, read it later. It's really interesting. All right, so these laws are all called the Sunshine Laws, open meeting, public records, conflict of interest law, and they're essentially the three-legged stool of Massachusetts municipal law. Anyone heard that before? Only if you've heard me talk about it. So they exist throughout the country, and in Massachusetts, we had a terrible reputation under the public records law. It was like number 48 or something in terms of what the reach of our public records law. One of the main issues with the public records law was that the legislature and the governor were not subject to the public records law. So they totally rewrite the law, and guess what? They're still not subject to the public records law. And they did that change in the middle of the night on a Saturday. So much for transparency. The idea, of course, is to make sure that the town's interests are the interests that you are representing and that you're not representing personal interests. Also that people can participate in both the policy that's being made by boards and committees and also has access to those records. Open meeting law starts off with the presumption that all meetings are going to take place in open session. All meetings of public bodies are going to meet in open session. And that means people look skeptical. No, really, it's true. That's the base requirement, is that you have to assume that every single meeting, which is a meeting amongst a quorum of members of the board, has to take place in accordance with a properly posted meeting notice for which at least 48 weekday hours is given, and the notice itself has to be very specific. So, any of you who were on boards or committees before 2010? Okay. So under the old open meeting law, you didn't have to really give very much notice, just time, date, and place, 48 hours, and that was that. So the new open meeting law makes a huge change to that. Public records law also changed since 2017. The public records law provides that all records made or received by a public official or employee are public in their entirety unless they fit, or portions thereof fit, into one of the strictly and narrowly construed exemptions. So when you start off thinking about public records and open meeting, you have to start with the concept that everything you do is a public record and can be reviewed by anyone who wants to, and you can only talk to a quorum of members of your board at a meeting, at an open meeting that's been posted. Finally, the conflict of interest law, the job of the conflict of interest law is intended to make sure that the town's interests are being represented. Anytime someone either has a direct financial interest in something or appears to have a direct financial interest, that they have to either disclose that and get approval to participate, or if they're elected and they have a financial interest, that they can't participate at all. So, what types of meetings are subject to the open meeting law, what rules need to be followed to hold a meeting, what are common violations. So because this is from a law, every word in the definition of meeting is basically another defined term. So I'm just going to try and simplify by saying a meeting is whenever a quorum of the public body discusses something within its jurisdiction. So if it's a properly posted meeting, then that's an appropriate discussion. If it's not a properly posted meeting, then it's not. What's a deliberation? A deliberation now specifically includes email conversations. It was the case in all counties but one prior to the law being changed, but the law was changed to require that all emails are now considered to be subject to the open meeting law to the extent that they involve a quorum of a public body, talking about a matter within its jurisdiction. You don't need to hold a meeting to schedule a meeting, but anytime and people share their ideas, feelings, beliefs, or concerns in writing, that's akin to being at a meeting. So if you have a quorum that you're sharing your feelings, ideas, beliefs, and concerns, it's a violation. Whether it's a serial conversation, so if the three of us are on a board and I talk to you, well, now that's a violation. If there's 5 people on the board and you talk to one other person, now that's a violation as well, even though it didn't happen at the same moment. Okay, so it can happen over time or it can happen all together at once. Yeah?
What responsibility does the town have then for people like myself who are on a volunteer committee? We have only our own personal email accounts. What responsibility does the town then have to provide each one of us a town of North Andover email account so that those emails can then, so that there's considered no commingling between my personal account and.
Well, and that's even more of an important question because your emails are considered to be public records as well. So if you don't use a particular, what we typically say is that if the town wants to, it can provide all of its volunteers with email addresses, but sometimes the town can't do that. I will recommend that you create your own, Gmail account that's just for this purpose, use it just for this purpose, and that you copy an administrative person in the office or in town hall or an administrative address so that all of that is automatically saved on the town servers and you don't have to worry about it. I don't know exactly how it works here, but we'll find out. Yes?
I assume that electronic mail includes all electronic communications, including group chats or whatever.
Absolutely.
Okay.
Yep, and we're going to talk more about that as we go. Yes?
When you said that if you don't post a meeting appropriately, is that meaning that it's not a legal meeting then after it's happening?
It's not a legal meeting.
So what happens then? None of the work that's talked about there is viable, or what do you mean by not a legal meeting? Are we going to jail?
I was going to say it depends, but now that seems like an inappropriate response. You're not going to go to jail, but a complaint could be filed, and a complaint to the extent that the Attorney General's Office of Municipal Government decides, that a Division of Open Government decides that was an intentional violation, they can assess a fine of $1,000 against the town. So it's not against individuals personally, although that was part of the bill, it's against the town. But we're going to talk more about that. All right, so what's a quorum? A quorum is a full complement of members of a multiple member body. Meaning, if you have a 7-member multiple member body and there's only 5 members appointed, a quorum is still 4. The only time that those quorum requirements don't apply like that is if you are, it's very, very limited. Conservation Commission meeting to take action under the Wetlands Protection Act. It's the quorum that's required for action is a quorum of those then in office. Anyone think why? Conservation, we don't want to destroy our resources, let the people act is basically the underlying thing there. And then what's a public body? So it used to say governmental body, now it says public body, a multiple member board, commission, committee, or subcommittee. What this really means is that any time a board or committee creates a subcommittee, whether it has the members of that board or committee on it or not, it's going to be subject to the open meeting law. So if you are appointed by a board or committee, you're likely a board or committee for purposes of the open meeting law. If your committee is found in the bylaws or in the general laws, subject to the open meeting law as well. Every once in a while there can be a committee that's not a quote-unquote public committee, and that might be, for example, let's say the school committee is thinking about some curriculum changes and they say, every Wednesday for the next 3 weeks we're going to meet to discuss curriculum issues generally. Come, don't come, it's up to you, but we'd love to see you guys. So if you go for all 3 weeks and some other people do, there's no one said you're going to do anything in particular. You're not being formed by another committee. You have no function really except to provide some feedback or input. The other example is for a town manager or chief of police or fire chief, somebody who has a statutory or right under a charter to do something on their own. So for example, school superintendent has a right to appoint principals. They do not need anyone else's approval. Under state law, they can appoint the principal. So then there's a case that says where the superintendent appointed a committee to help the superintendent make a choice. That wasn't a committee of a public body. It was a committee of a public official, which did not make it subject to the open meeting law. So if a single official has the ability to do something under law by themselves with no input, then they have the ability to make a committee. That's not going to be subject to the law. Okay? All right, so more subcommittee information. The idea of when you create a subcommittee, it doesn't have to be formal or intentional. It's essentially any time 2 people are authorized to act collectively from that board or committee. So for example, if you are on the finance committee and each person on the finance committee is designated as a liaison to one board, another board or committee, or to one department, that person who is designated can go to that finance committee meeting and go to that committee meeting and listen, and then come and report back. If, however, 2 people, and that's not a violation of the open meeting law, there's no issue. If 2 people on the finance committee were designated as liaisons to, let's just say, the Park and Recs department, then they're being designated to act collectively, and they're subject to the open meeting law. They're now a subcommittee, and they have to post. Another example is in a situation where, and this is a real life situation, which is an unfortunate story, but the Board of Selectmen in a particular town said, we really want these bylaws to be reviewed. We're going to make all of you department heads and you, Mr. Town Manager, a committee for the purpose of reviewing the bylaws. And they said, okay, well, we'll do it. But they didn't post because they didn't think they needed to. But the board had actually appointed them as a committee to review the bylaws. So every time these department heads had a meeting about the bylaws, they had to post it. If they hadn't done that and they just said to the town administrator, can you please take care of this? We'd like to have these bylaws reviewed. The department heads could have gotten together and provided input back on that because they wouldn't have been a committee. It would have been the town administrator essentially assigning responsibilities to other people versus a committee that had a responsibility to provide recommendation. One person does not constitute a subcommittee, so if you have tasks that need to be done, it's much better to just assign it to one person. If that person seeks some assistance from another member, it's different than that person being authorized to act collectively with that other individual. So a 5-member board, I get a lot of questions about someone who's been designated to take the minutes. They are preparing the minutes, and they will call another member and say, can you look at these? Did I get that right? That's not a violation of the open meeting law if it's just 2 out of 5. Okay? And it's not a subcommittee because they haven't been designated to act together. On the other hand, if it was the 2 of them that were told to go back and write the minutes, they would have to post under the open meeting law. Okay. All right, so what does the open meeting law require? Essentially, there's 3 major issues. The first one is the timing of the notice, the location where the meeting can be held, and the level of detail that's required. Second main issue is the purpose, the presumption for an open session, which we already talked about, and then this limited authority to meet in a closed session. And then lastly, the minutes. What's in them, what's the timing for approval, for creating them, and what's the timing for approval. So if we go back to timing, a meeting notice has to be posted no less than 48 weekday hours prior to the time of the meeting. And the AG takes this all very seriously. Under the old open meeting law, the district attorneys from each county would enforce, and they'd say, you made such a good effort to post that by, at 6:05. It's not a big deal that you started your meeting at 6. It's a minor violation. Don't do it again. Under the current open meeting law regime, that would just be reported back as you have violated the open meeting law. You need 48 weekday hours posting. And that 48 weekday hours, so that doesn't include Saturdays, Sundays, or legal holidays, all right? It has to be posted in a location that's accessible 24 hours a day. And I can't recall what you guys do.
Website.
You have your website designated as the meeting notice location. So it has to also be posted at the clerk's office, but the meeting notice requirement is met by posting on the website. And the other thing is that meeting notice has to be, the meeting has to be held in an ADA accessible location. There's nothing in the open meeting law that says that, but the Americans with Disabilities Act requires that. So you can't really meet at someone's house, you can't meet, in a building that's not accessible for people with disabilities. That does not rule out non-municipal buildings, however. So for example, you have elections perhaps in a church or a temple or a mosque, or you might have a meeting in a nursing home which is open to the public in an area that's open to the public. The idea is that people can come in and the public is welcome there. And then lastly, and this is the most important part, is the level of detail that's required to be on the meeting notice. So how many of you have been chairs and had to prepare meeting notices? Okay. Meeting notices, it used to be enough, you put down the time, the date, and the place, you post at least 48 hours ahead, you could post for the whole year with one, kind of like placeholder. Now that is not enough to meet the requirements of the law. Each meeting notice matter has to be separately itemized. So the law says it's topics to be discussed at a meeting, but really it's the items to be discussed, the particular items. So the example that we hear a lot of is, let's say one of the first cases that they decided at the new Division of Open Government was in the town of Freetown, and it was on soil removal permits. And in that case, the board had put down an item that just said reapprove fall soil permits. And there was a complaint made because it did not include the name of the person asking for the soil permit and the location at which they were asking for the soil permit to be provided. So that tells us that in every case, we need separately itemized matters. If you guys have 5 hearings, you need to write out the full name of each of the hearings, and you have to include enough so that basically people understand what's going to be discussed. I say it's a little bit like the opposite of town meeting. At town meeting, you look at an article and anything really could happen within the scope of that. It could be related but not exact. So if you're interested, you have to go. Here it's kind of the other way. They're looking for you to actually tell them what they're going to talk, what your board or committee is going to talk about. You're not supposed to use acronyms. Not everybody knows what those acronyms mean. And if you're going to have an executive session, you have to include that on the meeting notice. Sometimes chairs are really uncomfortable about that because they're like, we have to vote to get into executive session. We haven't taken a vote yet. That's okay. It's what the chair reasonably believes is going to be discussed. And the chair is going to bring up the issue of executive session. So you can't say HUD, or if you have a local committee that goes by an acronym, you can't use that in the meeting notice. You have to assume that someone who doesn't know what's going on in town is looking at that.
What's an executive session?
Oh, what's an executive session? That's when you get to meet in private,
Oh.
or when you improperly email amongst a quorum. So yeah, there's very limited reasons. We're going to get to them.
Okay.
What board were you?
Sustainability.
Okay, so that's why you probably don't have a good reason to meet an executive session. You have to have one of these statutorily enumerated reasons in order to go in. Purpose. So the purpose for the open session, as I said, there's a presumption for an open session. Even though that presumption exists, if you are only going to be meeting an executive session, you have to include an item that says open in open session, or call meeting to order, or something like that, so that people understand there's going to be an open session before the vote to go into executive session. And then minutes. Minutes is another area where there's a significant change in the law. How many of you have been at meetings where someone says, I spoke for 20 minutes and you wrote one sentence about what I said, and she spoke for 1 minute and she had 3 paragraphs in there. Have you heard this? She said this, I said this, he said that. Well, that was under the old law. We said you have no obligation to do that. Don't bother. Just do a summary. And the summary could be, discussion regarding potential for an override, and that was it. That was good enough. Now you have to have who asked questions, what the answers were, and enough so that someone who wasn't at the meeting actually knows what happened at the meeting. Now, for those of you who are minute takers, that is not easy at all. Yes,
What if it's televised?
even if it's televised. Now, you don't have to take your minutes contemporaneously while the meeting is ongoing. You can, go back and look at the tape for the ability to kind of do the minutes. Some people can't type or write as fast, and they'd rather do that. Interestingly, if you don't take minutes at the meeting, though, that tape is a public record as of the moment of its creation, subject to mandatory disclosure upon request, because it is the minutes of the meeting until meeting minutes are prepared. That's one of those things that we hope that the open meeting law itself will catch up with, but it hasn't yet. All right, timing. So you have to approve your minutes within 3 meetings or 30 days, whichever is later. Okay, it used to not, there was no timing required, now that's a timing requirement. And now there's a different way of approving minutes than there used to be. This was in a regulation promulgated by the Division of Open Government, and basically it's that you can do it the traditional way, which is one person prepares the minutes, bring them to the meeting, you talk about them, you change the words, you take a vote to approve. Or if you're bored, and I always say, I think the Attorney General thinks there's a lot of boards out there that get along great, because the AG says one member of a board can be designated to approve the minutes on their own. So that means everyone has to agree that that person will do a good job. And then the last way is to do it as a consent item agenda. Does anyone have consent items on their meeting notices? Basically, it just goes at the bottom. It would be there, and unless someone objected to one of those items, it would just be voted in one vote. Okay? All right. So you don't have to have a meeting to call for a meeting, and that's what the first issue is. You can just, not you, a staff person has the ability, or the chair, to distribute a meeting agenda to discuss scheduling or procedural information, and to forward reports or documents that may be discussed in an upcoming meeting. But those reports and documents cannot be an individual's ideas, feelings, beliefs, and concerns or perspectives. It has to be somebody else's that are being forwarded. The idea being, if you share your ideas, feelings, beliefs, and concerns, whether it's in an email or a memo, that's a violation of the open meeting law, because the discussion about your feelings, ideas, beliefs, and concerns should occur at the table. Okay? So a staff person might be able to distribute, or a chair might, as long as they're not sharing their own feelings. Now, one of the things that's difficult about this is that a lot of times people or committees will allow any member to request an item to be included on the agenda. Is that how you guys work things most of the time? So, assuming that then you send it to all, I'd like this to be on the next agenda, whatever it is. And someone writes back and says, absolutely, that's such an important issue. That's feelings, ideas, beliefs, and concerns. It's a violation of the open meeting law. So it's very tricky to kind of get everyone on board to follow the same rules with respect to this. If someone wants if the rule is that everyone that gets copied on emails, then you can't share your ideas, feelings, beliefs, and concerns about why that item is important. If all that one member does is send it right directly to the chair, as long as it's a 5-member board, that's not going to violate the open meeting law. However, if the chair then talks to a third person and says, well, Lauren said that was a really good idea because it's so important, now that's a violation of the open meeting law. Okay? So I'll tell you a story. A woman who was one of the founding partners at the firm, she, when I got there in 2000, invited me to go out and do a public records and open meeting law training. She do the open meeting law, I do public records, and I was like, of course, I'm not going to say no to that. So I went out, and when she got to the open meeting law part, she talked about how people were not allowed to speak to one another outside of a meeting, and like prohibited. It wasn't allowed. And so I was, surprised, because it's the law says it can't be amongst a quorum. And so we talked about it afterwards. She goes, you can't tell them that they can talk to each other without violating law, because then they will violate the law. And there is some truth to that. You feel like you can have that kind of a conversation, but it's easy to tip it past the point where it would constitute an open meeting law violation. So if you're going to either have an email policy or a conversation policy about agenda items, it has to be, please include this, not because I think it's really important or because this is an issue that's been, raised at numerous meetings and we really need to take care of it. That because, or that, it's important, that language is what constitutes a violation of the open meeting law amongst a quorum. Okay, so attendance at an on-site inspection is not a meeting for purposes of the open meeting law. Any ideas? Why? Because a site inspection is often at a private location where the public is not welcome and a place where it may not be accessible under the ADA. So site inspections do not constitute meetings except if there's a deliberation, and then it would be a violation of the open meeting law to do that. So a lot of boards and committees will post their site inspections as meetings. You guys post as meetings? Yeah. So if you're doing that, you need to be thoughtful about what happens if people show up, right? Because they're not necessarily welcomed on the property. The owner of the property has the right to say no. It's a best practice to, instead of discussing the matter at the site inspection, you can ask the questions you need to ask. Don't say, oh, that's a great idea, that's a great point, because as soon as you share your ideas, feelings, beliefs, and concerns, that's going to be a violation. But do schedule a meeting at town hall or wherever right afterward for the purpose of then deliberating over what it is that you've seen. Okay? So the idea is at the site inspection, you're not discussing amongst yourselves, but then you schedule a meeting where you come back and you have the opportunity to do that. If you have a very well-behaved board, then that works. And I say well-behaved as in non-chatty. If you have a chatty board, then you might want to think about not doing the site inspection altogether. Whatever you do, don't ride in the car there together. Don't ride back from there together. Okay, attendance at a public or private gathering or social event. So under the old open meeting law, the second you had a quorum in a room, it was a violation of the open meeting law. Period. Didn't matter what the reason was, why you were there, violated the open meeting law. Now there's more of a recognition that that's not necessarily a violation. My position is always to be proactive rather than reactive. So if you wind up at a party and all the members of the Conservation Commission are there, you don't need to stand with all of them and whisper in the kitchen, as a group did that I personally witnessed, so that everyone is like, what are they talking about? You think it's that controversial thing? Yeah, it's gotta be. Because that's just gonna set it up for an open meeting law violation. And one of the things that, I hope that you guys take away from this is that it's so much better to actually have someone challenge the substance of what you do, because if they're saying you reached the wrong conclusion because you didn't have enough facts or this or that, rather than because you discussed this outside of an open meeting or because you wouldn't provide someone with a copy of a record. So being proactive, if everyone is in the kitchen, walk away. And definitely don't do what the finance committee in one of our towns does, which is they go to dinner every single week after their meeting. And they're like, well, it's in public. Anyone who wants to listen to us can. And it is a violation of the open meeting law because they're talking about what they just talked about at their meeting. So, and they don't believe that that's a violation. So, best practice, don't do that. If you are at a private gathering or social event, or the other option is at a meeting of a posted meeting of another public body. This is a situation where, for example, maybe the zoning board is hearing a 40B application, planning's interested, board of selectmen are interested, and so a number of board members from other boards come to the meeting. That's not automatically a violation of the open meeting law either. But what I recommend is that you don't sit with the other members of your board. You don't whisper with the other members of your board. You drive yourself there and back. You do not drive with other members of your board. And all of my anecdotes are, of course, things that have happened where people have gotten complaints filed against them. You don't have to post your meeting. You don't have to post a meeting if you're just a board that's coming to another board's posted meeting. And individually, you have the right to get up and say, you know, I am a member of the Conservation Commission, but I'm here tonight as an individual or as a resident or whatever it is. You know, I have some concerns about X, Y, or Z. The problem becomes if you turn around and you say to your board, right? Don't you guys think that's really important? That is an actual violation of the open meeting law. It's a deliberation. So if you have a chatty board, you should post. Okay? If you don't have a chatty board and you really feel like you can ignore the other people and you're not going to ask them questions, that's one thing. We all know there's some boards that have more issues with that than others. So you know your board. If you're the chair, post if you think you need to. That's how you avoid the problem. Here are all of the things don't represent. Okay, if you do want to post your meeting, you're going to post it at the same time and place as the other meeting. You're going to open your meeting, you can sit together, but just remember you shouldn't be whispering. Because whispering amongst a quorum also violates the open meeting law. Seriously, it does. Town got a complaint filed against him and the AG found an actual violation because 2 members of a 5-member board leaned back behind a third member to talk, and the actual conversation was, I really need a break. Can we please take a bathroom break? And the chair of the meeting said, of course we can, just give me a minute. That was the actual conversation. You can hear it on tape, and the AG said it was still a violation because 3 members of the 5 members could hear it. All right, so email. We already talked about this a little bit. The risk of using email is that you'll share your feelings, ideas, beliefs, and concerns among the quorum. And I've said that 10 times, I'll probably say it 10 more, because hopefully that's going to be a sign for you. If you say, I think, I feel, I wish, or I agree, that's important, or anytime you're giving a position on something that's going on in front of your board, you are participating in an email deliberation, okay? Now, the AG has said just getting that email constitutes a violation. So it's not as though it's a single individual who violates the law by sending that email, sharing their ideas, beliefs, and concerns. It's the recipients, too, that violate the law. Just receiving it is a violation of the law. So sometimes you'll see one board member file a complaint about another board member under the open meeting law because there was private emailing or something. They're filing the complaint about themselves, too. Because it's the board that the violation applies to, not an individual. So how do you avoid violations? The number one issue is don't reply to all. Okay? Don't ever reply to all. Just reply to the sender. Replying to all creates the problem or the possibility that you violate the law by saying, great idea, let's do that. Okay? So I like to say that button doesn't exist when you're emailing about town-related matters. It's not there, it's not an option, you can't use it. Okay, reply to all is bad. If someone is scheduling something, so you reply just to the person that's scheduling. I am free on Wednesday. You don't have to write to everyone else, I'm free on Wednesday, but this can't wait, me without me. Now that you said this can't wait, that's a feeling, idea, belief, or concern. It's a violation of the open meeting law. Limit the use of email to scheduling purposes. So it really is a good trick. In our regular lives, day to day, we probably email about lots and lots of things. If you're a volunteer for the town, it's best to just use email for scheduling. If you're in that habit and you're only using it for scheduling, then you're unlikely to violate the law by sharing emails amongst a quorum. Now, some of you, I do a training in a town every year. The Water and Sewer Commission sits right up in front, although they sit on that side. And every year the chair says to me, so you're telling me I have to go into a meeting the most unprepared I can possibly be? I say, basically, yeah, that's what you got. You are supposed to be doing your thinking at the table. You're not supposed to be coming in with your mind made up about something. You have to have that discussion at the table. So limit email to scheduling and you won't run into the problem that you're kind of making policy outside of an open meeting. For a totally different reason, it's also good not to send emails because they wind up in places you did not intend. On a blog, posted to a bulletin board, in the inbox of a person that you mention in your email. And that's forever. You can't undo it. So the other thing to be cognizant of is a lot of times we are emailing people we know, even if it's just about scheduling. And then at the bottom of the email, you might say something like, oh, I heard your mom had a fall. I hope she's okay. Did you take her to the hospital at MGH or did you? That's personal stuff. Your mom has, or that person's mom has a privacy interest in the fact that she was hurt. You don't want to put that in an email with town business, because if a request is made for your emails, you're gonna have to go through all of those and identify which things are personal and which things are not, or you're gonna give out things that are really not germane to the town. So I really suggest that you pick a different email address to use for your email for work-related matters, for town work-related matters, and that you email someone separately from your other email address when you want to check in on them. So you could send one email from your town email address and then jump onto your other email to send out a note to that same person saying, hey, I just wanted to check in on your mom. I heard she had a fall. And that way, one is personal, one is public records. All right, here we go again with opinions, ideas, feelings, beliefs, or impressions. Okay. Now, as the woman I told you about who gave that training session in 2000 said, it's best to act like you can't talk to anyone outside of a meeting about what you're going to talk about at the meeting, because that way you ensure you're not going to violate the law. I know that people have an inclination towards talking outside of meetings or emailing outside of meetings. So you just want to be really thoughtful about that. Again, forwarding someone else's email or telling that next person what you talked about with the first person is going to create a violation. Okay? And it's better to avoid that altogether than to open your decision-making, whatever it is, up to a challenge. Social media. How many of you guys use Facebook? That's it? Facebook users? All right, okay. And we're not going to admit it. My kids won't use Facebook. They act like I'm a dinosaur because I do. But Facebook and Twitter and Instagram, I have to try to remind myself, that's it. All of that is subject as well, all that communication is subject to the open meeting law. So what the AG has said you cannot do is post something and directly call out the other members of your board. Okay, so you can't like tag them in your photo or whatever it is, or in your tag, in your comment. If the matter directly involves issues that are pending before your own body, you should think twice before posting anything about it at all, whether as an individual or in your official capacity. The idea being that, especially for land use boards, you're adjudicating people's rights. They have the right to have all the evidence that's going to be used at that to make a decision be entered into evidence at the hearing. If you're taking a position ahead of time and you're predetermining what your position is going to be, and or you're soliciting information that's not going to be part of the public record, that's not a great place to be from that perspective. So consider not engaging. I gave a talk like this to a room full of city councilors at one point, and they were like, that's our job, is to engage, and that's where we do it. It's on the internet. I was like, well, you need to rethink that. Be thoughtful about the manner in which your comments are made. And this is one of those things I know we all tell our kids, that'll be out there forever, but it really will, and especially when you're representing the town, you want to be thoughtful about how you make comments, especially on those community Facebook pages. People can get really riled up and say things that just aren't great, and then people respond to them. So try to avoid that. I like the 10-second rule, which I really like to be the 1 hour rule, which is as soon as I go to type back something and I'm angry or upset, and I go to write that and I realize I'm angry and upset, I'm like, I have to wait. I can't send that right now. I'm going to wait until I'm not angry and upset. So try, if you start, I think you, or I feel that you are, you need to take a step back from that and think about whether you want that to be out there. How many of you guys are elected? Okay, so elected officials should be careful about using their kind of campaign email address or Facebook page for their official town work. As a candidate, you might be advocating for a particular thing. An example is affordable housing. A selectman in one of the towns we represent was a huge affordable housing advocate her entire campaign page was covered with her stance on affordable housing. And that was great, and she got elected because of it. But then she had all this stuff out there, and now we have developers coming in and, opponents. And so the idea that she and I discussed was to take her campaign page and just say, I was elected to serve as in the Affordable Housing Trust. At this time, I'm going to be posting matters here that may be of interest to you, and I will reopen this as an active campaign page when the next election comes around. Applicants have due process rights. This is an expensive point. Remember that due process, that's it's a constitutional claim, so anybody who's having their rights adjudicated can argue, well, the board completely pre-decided this. See, 3 of them posted on Facebook saying that they were in support of this or they were against this. And that would be a good argument, that they were biased or that they made a predetermination, they didn't base their decision on the matters in the record. Okay, personal use of social media. If a public official or employee wants to use social media, the idea is public versus private, and also what are you using your public site for? What we typically would suggest is that you say, this is my private page, or this is my town official page, in the about, so that it's very clear. The general agreement on what an official Facebook page can be used for are things like public announcements, emergency alerts, event reminders, things of that nature, more as an informational hub than a position hub. And the other thing is that to ensure that you're not kind of crossing over into an area that could either negatively impact the town or could negatively impact your board, be careful not to debate or discuss with the public on your page. You're an individual when you're on your page. You don't represent your board or committee unless they have appointed you to do so. They voted to have you represent them. So if you're on your page saying the planning board thinks da-da-da, or the Conservation Commission's taken the position that, you don't really have the right to be making that statement. And so it can turn things kind of into a problem. People don't understand whether you're authorized to make decisions. They might think that you are, when really you're just kind of reporting the stance of the board. So be careful not to go back and forth with members of the public. Yeah?
How could you write an editorial then?
You write it as an individual,
You have to mention that in the editorial,
typically.
or in the signature or something?
Typically. You're not supposed to use your office. That's more of a conflict of interest law question as well, but you're not supposed to use your office to kind of promote or oppose different things, seek benefits or privileges for which other people aren't entitled. And so it depends. If you're elected, you have a much broader ability to talk about things that affect the town generally. If you're appointed, you're really more limited to talking about things that are within your official responsibility. And so if you're a board member, unless the board votes to authorize you to represent it, you can only speak as an individual. Yes?
Do you consider a poem, a thought, a feeling, an observation? I mean, what are they? Because we do them.
No, you don't. Hypothetically,
We do.
hypothetically, a feeling, idea, belief, or concern would be anything that's expressing your position. Okay? No poems. Unless someone else wrote it.
And poetry selection too.
All right. The meeting notice. Okay, we already talked about it has to be posted. Date, time, and place. We talked about that. The list of topics have to be with sufficient specificity to reasonably advise the public of the issues to be discussed. All right. So posting requirements for a Monday meeting. The notice has to be posted on Thursday. Okay, so just keep that in mind. If Monday's a holiday, a Tuesday meeting has to be posted on Thursday. The clerk should timestamp the notice to ensure that an accurate record exists of the filing. Sometimes those are automatically done electronically, sometimes they're done in hand. If posting is made in an alternate location, it has to be in both. And then a meeting cannot be continued from one night to the next. unless the meeting's been posted to go from one night to the next. That makes sense? People used to just continue meetings from one night. You can't do that. Even if you have to continue a public hearing, it has to be far enough in advance that you can post at least 48 hours prior to the time of that meeting. Yes?
What is a definition of posting at this point?
Posting on the website.
Okay.
Okay? And then the notice required under the open meeting law does not substitute for or otherwise supersede other notice requirements. So conservation, planning, licensing, zoning, any notice that's required under another law, that's completely separate and apart from the open meeting law. The open meeting law requires that this particular notice be posted in this particular manner. So, for example, under the zoning act, if you're going to do an amendment to a zoning bylaw, you have to publish a notice, two successive weeks, saying kind of what the bylaw change is about. That's great, and it has to be done, or the bylaw amendment can't be approved by the Attorney General without a whole nother process. But it doesn't substitute for the open meeting law notice. Okay? So you have to post this notice no matter what, and it's not a substitute for another. Okay. I already said all those things. Okay, so the meeting notice is going to include the matters that the chair reasonably anticipates will be discussed at least 48 hours prior to the meeting. So what does that mean in terms of what you can do after the 48 hours? So you are supposed to update your meeting notice if something the chair wasn't aware of is going to be discussed at the meeting, and it arises after the 48 hours. So in one of the towns we represent, they had this beautiful bike path. They wanted federal money for that. They were told they had to have a bike committee appointed by certain individuals, by Board of Selectmen, by the end of, I think it was October. And then one day in August, the town manager got a call in the morning of a meeting of the Board of Selectmen that night, and they said, they changed the rules, didn't anyone tell you, where's your bike committee appointees? And she said, well, we haven't done that because it's, end of October. They said, no, if you don't get it done tonight, you don't get the money. So the chair wasn't aware of that. She tried to reach the chair. He was on a plane. She couldn't get in touch with him. She didn't know what to do. So she didn't update the meeting notice because she didn't know what the chair would want her to do. And as it turned out, she raised it later. They did make the bike appointments because it wasn't reasonably anticipated by the chair. But of course, an open meeting law complaint was filed. And the AG said, no, that couldn't have been reasonably anticipated. It's not a violation. You can discuss something that comes up at a meeting that that the chair didn't reasonably anticipate. Okay? So you're not prohibited from doing that. The AG strongly recommends, and this is in all of their decisions, that a matter that's brought up at a meeting for the first time that's not on the notice be pushed forward to the next meeting. Because the position is, if people are interested in it, then they should be able to come and hear about it. And if it's not on the meeting posting, then no one will know. Okay? But it doesn't prohibit the discussion. The AG recommends it be pushed forward. I often recommend it be pushed forward too, but for kind of a different reason. My feeling is that if there's something that comes up that the board or committee isn't prepared to address, then the risk of people kind of getting into it with the crowd is much higher, right? If you have time to consider whether you have an appropriate policy in place and you come to a meeting, you've at least read that policy that you have, you've heard, you can look at both sides of whatever the issues are, and then you're ready to kind of talk about that. Versus having someone say right in a meeting, you don't have this policy and that's a violation of something, and you're going to answer, or board members are going to answer because they feel like they need to be responsive. So you don't have to get involved in a back and forth like that. You can just wait till the next meeting if there's time. Also, I should have mentioned back on the email, if let's say you look at an email chain, not an email chain, a post on Facebook or something, and you see, if you're a 5-member board, that 2 members have posted before you. Obviously, the choice you should make is not to post, okay? Because that's going to now be 3 people sharing feelings, ideas, beliefs, and concerns. But, and this is what I've heard from, especially from city councilors, they don't want to look non-responsive. They don't want to look like they don't care. So what we've talked about them doing is typing something like, because of the open meeting law, I'm going to share my feelings, beliefs, concerns, whatever, at the next meeting on whatever date. obviously, I look forward to hearing from constituents at that time. And then on their own personal Facebook page, posting notice of that meeting and saying, you know, we encourage people to, or I encourage people to come and provide feedback. So you can say something like, the open meeting law doesn't allow a quorum to weigh in, so I'm not going to weigh in, but come on Tuesday, and you know, you'll hear more than you want to, or whatever it is. That was a joke. That's right. Okay. So this is talking about what's reasonably anticipated by the chair. If you update your meeting notice because something comes up, you have to show what that is on the meeting notice. You have to show what's new. And you also have to show the time that the new updated agenda was posted. Okay, so that should get marked right off. Okay, placeholders are a no-go. I really wanted the Ghostbusters guy right there, but I couldn't figure it out. You can't just put something on your agenda, old business, new business, and act on anything that comes up under that because someone feels like it. If there's a particular business that's going to be brought up, that needs to be listed separately on the agenda. Same with like a DPW superintendent report. Like the Board of Water and Sewer Commissioners will have the DPW superintendent give a report every week at the meeting. It can't just say report. It has to be like water usage, update, whatever the factors are that they're actually going to talk about. And yeah, there's things that happen in day-to-day life that you know, the superintendent may not remember to tell the chair, but might realize later, oh, there's also this other thing. Under the law, they're allowed to talk about that other thing, but the chair could also say, you know what, that's a big deal, let's wait till next week to talk about that. Okay? All right, emergencies. So failure to be aware of a filing deadline is not an emergency. That's a self-created problem. Or a constructive grant deadline, that is a problem that one brings upon oneself. That is not the same thing as an emergency for the open meeting law. Has to be something essentially that you know, results in the town having to have a swift reaction. Natural disasters, public safety issues do qualify as emergencies. Comply with the law to the extent that you can, meaning, so for example, in Swampscott a few years ago, April 1st, there was a giant storm. It was also the day of their annual town election. They were trying to decide what to do. They talked on the phone because the water was coming over the seawall right down the main street. They talked on the phone. They decided to cancel the election, and they took minutes of their meeting. They also had the town administrator post a meeting for, 48 business hours in the future. And then at that meeting, they ratified, validated, and confirmed the phone conversation. And they also adopted the minutes from that meeting, it was an emergency meeting, as part of the minutes of this properly posted meeting. So do what you can to comply with the law. So the chair has to make a public statement about audio or video recording. If an attendee intends to record, they're supposed to come and tell you now. That used to not be the case. The chair can reasonably regulate where the recording information goes. So you can require that someone leave their tape recorder on the table rather than run around from person to person. I actually saw it at a couple of meetings. It was great. Really exciting. All right, executive session. So how many of you have participated in an executive session? Okay, fair number. You have to convene an open session. We already talked about this. You have to state the purpose of the executive session, stating all the purposes that may be revealed without compromising the purpose for which the executive session was called. So let's just take executive session of the Board of Selectmen and talk about a single collective bargaining contract. Well, if the discussion of the potential negotiation with that union is not a giant secret for some reason, then the name of the union would go in there, right? Executive session, negotiation with respect to collective bargaining, blank, blank union, okay? Or let's say it's the ZBA dealing with a potential appeal. So it's a litigation matter, so they go in under the litigation exception, and it would include the name of the particular matter and the address, unless doing so would kind of tip off that property holder that there's going to be an issue. So each of these is a case-by-case decision. You have to take the vote to go into executive session by roll call. You also have to record everything in executive session by roll call. Unanimous is not the same as recording everybody's vote, Okay, you don't know exactly who's there, someone could have left, so you need to record each person's vote separately. You have to maintain the exhibits and documents used in a reasonable proximity to the minutes. That means if someone gives us a presentation or something during a public meeting, and we're like, we're never looking at this again, and we go and we put that in the archives, and someone comes in and says, I'd like to have a copy of that presentation, we can't charge them to go and look for it. It has to be in a reasonable proximity to where the minutes are maintained. In executive session, the only thing you can do is talk about the matter that you're in there for. These are purposes, so I did provide cards that list these purposes for your convenience. In some of these exemptions, the chair has to declare that having a meeting in open session would be detrimental to the municipality's position. So only on those, and they're marked right on the executive session. So you can see that in number 3, strategy with respect to collective bargaining or litigation, if an open meeting would have a detrimental effect on the bargaining or litigating position, and the chair has to declare it. So if you're going to have an executive session on your meeting notice, you list out the entire purpose, the statutory purpose that you're going to be relying on, and then you write the kind of personalized part of it. So it would be to discuss value with respect to real property, or to discuss the matter of blah, 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 and blah, blah, blah. So those things will get added, but you're going to list this entire exemption. And the vote to go into executive session is going to repeat all those same things, and the declaration, if it's needed, also has to be made and recorded. All right, so what goes in? Yes?
Back on the purposes for executive session, what if you're in a committee that's going to hire someone, and you're reviewing resumes and talking about skills, et cetera? Is that open, or is that?
I feel like you're a plant to make this conversation take a really long time. I'm kidding. So you can only go into executive session if you're a committee that does hiring, if you've essentially appointed a subcommittee for that purpose, which includes less than the than the quorum of members of your board, or you go in under exemption 7, which is like a catch-all to comply with the general laws. If you were to go in under exemption 7, you need each and every candidate who's given you their resume or their application to tell you that they would not participate if their candidacy was known at that early stage in the process. As soon as you get to a semifinal stage in that second scenario, everyone has to be interviewed in open session. So as soon as you've gone through the resumes the first time, everyone comes in, goes into open session. With a committee, with a screening committee, the difference is you can go through 1 or more rounds of interviews in executive session until the body gets to the number of people that it's going to recommend. So let's say we're going to recommend 3 finalists to the Board of Selectmen. So we can go through and we can, 17 people, 15 people, 13 people. When we get to the 3, we're done. We can't meet in executive session anymore. But if you're under exemption 7, all you can do is look at the resumes and decide who you want to interview. I can send you a card on that too. Okay. So date, time, and place, members present and absent. 10 years from now, no one's going to remember the person that wasn't there. You need to write their name in there. A detailed summary, we talked about that. Decisions taken, decisions made, actions taken, and votes recorded. There's no such thing as a secret ballot in an open meeting or in a closed session. People just need to vote, and a list of the documents and exhibits used at the meeting has to be included as part of the minutes of the meeting. So those documents don't have to be included in the minutes, but they have to be listed in the minutes and available. How do we know if we've used a document? It's physically present, we verbally identified it, and we discussed it. So the difference is, let's say I referred to that presentation that someone gave to board members at the beginning of a meeting. Well, that document is physically present, but nobody talked about it and nobody identified it, and the content wasn't discussed, then it doesn't have to get listed. But if those 3 things exist, then it does have to be listed. Okay, we talked about approval.
For the documents,
Yes.
Do they have to be available to the public? How does that work?
They're public records, like any other, so yeah, that's why they're supposed to be in reasonable proximity to the minutes. because to the extent that they're part of the discussion, people should be able to look at them. If it's an executive session discussion, then they don't have to be available to the general public until the minutes are made available, and even then, only if an exemption under the public records law doesn't
But that would
apply.
have to be a request by the public to
Yes.
get the document.
Yep. Yep. Yeah, you don't have to automatically keep them there. You don't have to keep them there so if someone walks in the street, they can look at them. But you'd have the 10 days after.
Is the expectation that minutes will be available electronically or just on
Yeah.
request?
Right, so right now, there is a preference in the new public records law for electronic access to municipal documents. And what that electronic preference says is that if a municipality is able, because of its infrastructure, to include the minutes of meetings, those should be included on the website. Minutes are public records from the moment they're created. So if you are a clerk for a board or committee and you take minutes, those minutes are public records as of the moment they've been created. So don't write notes to the person next to you. Don't write about someone's outfit or something stupid that they say, because the second you do, that's part of the public record, okay? If you are the minute taker and someone comes up to you afterwards and asks you for a copy of the minutes, they are public and subject to disclosure. You have 10 days to disclose them, but the supervisor of public records likes to see you give them out right away, okay? What do? Your board hasn't approved them. What if they're not neat? None of that matters. Just write on the top of them a big draft and your initials and the date. And then people will know these were draft minutes, they weren't the approved minutes. Once the real minutes have been approved, the draft minutes can be discarded unless someone's asked for them. If someone asks for them, then you have to keep them. Tapes can be recorded over. So if you're videotaping for your meeting minutes and you get the meeting minutes that you've prepared approved, the tapes can be reused. You don't have to keep them for any particular period of time. And unlike most records, you don't need permission from the supervisor to destroy either of the things that we're talking about. You can just destroy them once the minutes have been approved, okay? And for those of you who are minute takers, I will make a suggestion, and just take it for what it's worth. You do not need to write down in the minutes, if things get really ugly, exactly the ugly things that people said. I had a court case once where the minute taker was very serious. She wrote down literally everything, and the judge called me over to a sidebar and said, "Who are these people?" I was like, I can't speak to that. So just be thoughtful about that. They do have to be specific, but they don't have to be exactly specific. All right, so executive session minutes can be withheld until the purpose of the session is concluded. At that point, they need to be released. Under the old open meeting law, they were released in their entirety. Under the new open meeting law, they can be released, but anything that's subject to an exemption under the public records law can be withheld. So let's just take, for example, a complaint made by a voluntary witness or complainant where there's discussion in executive session about this person and what this person saw and said. Well, under the old open meeting law, there was an argument that we should never disclose that, because if we did, we'd have to disclose the entire thing. Under the new open meeting law, we could take out the names and identifying details and protect it under exemption C to the public records law. Okay? If you're going into executive session you have two options to approve executive session minutes. And this is not about releasing them, it's just about approving them. You can go in under the same exemption you were under originally. So if you were under exemption 3 originally, you can go back in under exemption 3 to approve the minutes. You'd list the statutory exemption, and then you'd say approve minutes from whatever date the meeting was, okay? If you're going in to deal with approval of multiple minutes or multiple reasons for executive session, you might instead use exemption 7 to comply with another law, and that law would be the open meeting law, and then the different exemptions you use with the different dates. Exemption A, whatever the date is, and so you can go back in that way, okay? So those are two options for that. The AG essentially is requiring that municipal bodies review their executive session minutes on a regular basis to determine whether they can be disclosed. Okay, so it makes sense to have that. The chair is supposed to do that. If it's not going to be the chair, it can be someone else. But it's good. It's a good idea, especially if you go in regularly, to have a spreadsheet that shows when you guys were in executive session and why, and what would happen. That would mean that you could disclose those. So, for example, if it's a court case, you'd say, decision granted on whatever day. appeal period expires on whatever day, and after that, you could release the minutes. Okay, so having a spreadsheet for that purpose is a really good plan. At a minimum, though, someone should be going through it on a quarterly basis to make sure that executive session minutes that can be disclosed have been disclosed. Enforcement. How many have you guys had to deal with open meeting law complaints? Oh, really? That's excellent. A written complaint has to be filed with the public body within 30 days of the alleged violation. The public body has to meet and provide a response forwarded to the AG within 14 business days from the date the complaint is received. And the complaint can then be filed with the AG after the 30 days for further action, either because the board or committee did nothing or because they're dissatisfied, the complainant's dissatisfied. You have to put the matter on a meeting notice. It doesn't say this in the law, but this is what the AG says. So the date of the complaint, the name of the complainant, the body has to acknowledge receipt, should deliberate, meaning have a conversation about the allegations, and vote to resolve the complaint, and if appropriate, authorize a response to be prepared and sent to the Attorney General and the complainant. There's also a concept of cure. This is really important. If you know your board or committee violated the open meeting law because someone sent out an exuberant email about something that happened, you don't have to wait till a complaint is filed to fix it. You can just put it on the meeting notice and say, open meeting law, email sent to quorum and the date included as part of the meeting notice. Then you get into the meeting, you just acknowledge that happened and say, we're attaching that email to this, to these meeting minutes, and anybody who wants to can take a look at it. So that's the way that you cure things on your own. The AG has an enormous range of authority when it comes to open meeting law violations. They can compel, attend, and set a meeting, kind of like this one. They can require the creation or disclosure of minutes. They can nullify action taken, including employment decisions, which is huge. And then they can also impose a $1,000 fine for an intentional violation. There is a process to seek judicial review. It is really stacked against municipalities, however. We have seen a few municipalities prevail, but it's not an easy thing to do. So it's better to be in a position of not getting one of these letters than to get one and not like the action. The AG can file for in Superior Court anytime, and 3 registered voters can also bring an action in Superior Court. These are 3 of the decisions that that I was talking about. One of them, the first one, is important just from a due process point of view. Essentially, the Natick School Committee would only let people make certain comments during its open mic time, and the court came back, so this just applies in Natick, but it says when a multiple member body allows public comment or open forum, the public comment policies and practices must ensure that any restrictions are just specific and narrowly tailored to the public body's interest. They can't act as a limitation on speech. So it can't be a limitation on content. It could say you have 2 minutes. It could say you only get to talk twice if everyone else is done talking. It could say you only have 1 opportunity to talk, and at 15 minutes the debate is, or the public period is cut off. But you can't limit certain types of comments. Swansea v. The Attorney General. The Attorney General said that posting a list of licensing renewals at the end of the year on a bulletin board was not good enough for purposes of the open meeting law, the meeting notice and then this list, because, they had a link online. They didn't post it in the clerk's office, and the AG said, the court said, not good enough because it was completely subjective. Like, who's the AG to know how many meeting notices were posted on the bulletin board at that time? It's either one or the other. Either you can provide a link or you can't. So they said you can. And then this Bolter v. Board of Selectmen of Wayland issue is about the employee evaluation process and circulation of employee evaluations containing opinions about employment between a quorum. So I write my evaluation and everyone else does, and we switch them. That would be a violation of the open meeting law, even if we prepared them individually. All right, that was the open meeting law. I'm gonna go fast through public records, but I don't want to do that until any open meeting law issues are resolved. Anybody have any other questions about that? No. Yes.
I'm friends with two of the board members. I've been friends with them since 1956. So
How dare you?
if they call me up and say, hey, we're meeting at the VFW to
Right.
watch the Red Sox.
Yeah, you're gonna go
Now,
watch
the
the Red
three of
Sox.
us,
Yeah.
we're violating the open meeting.
No, you're not, as long as you don't talk about matters that are pending before your board.
Okay. We
Okay.
just talked about the Red Sox.
You can talk about the Red Sox, you can talk about anything else but matters pending before your own
Okay.
board. And, I mean, this is one of those things where people probably know that you're friends as well, so it would be less likely to be viewed as an intentional violation.
Yeah,
Yeah.
okay, thank you.
Yes,
What about cases where you are directed by your board, say, to represent them
Yep.
at another board's meeting?
yep,
For example, a selectmen's meeting.
mm-hmm,
So it's proper to do that, right? It's-
Yes.
You're expressing something that you discussed in your meeting, as long as you identify yourself properly, right?
yes,
And indicate that you are bringing that message.
on behalf of the board, yep.
And
Now,
that's the right way to do it, but do you need to notify anybody else?
no,
Okay.
but here's the thing, let's say your board nominates you to do that, and they give you the power to go up and represent the board, and you do, but your board's sitting right there, and you turn around and you say, was that right? Did I get that
Yeah,
right?
you can't do
That's a violation of the open meeting
Okay,
law, okay?
that makes sense.
Lauren, they
Yes.
have to take a formal vote for that, right?
Yes. Well, formal
You're
or
gonna
informal, it has to be known that that
It has to
person's
be in the
been,
minutes
yes,
that they
It would be in the
voted.
minutes.
absolutely.
But I don't have to submit any kind of notice that we would not have to submit a notice that we're doing that.
No.
We
There's
just have
another
to-
question in the back? Yeah.
So if you are in violation of the law, is it just one count of that, or depend upon how many people complain about it? Is the maximum fine always only gonna be
$1,000 for that violation.
So somebody could make a decision like, I'll pay the $1,000, I don't care, we're gonna have a meeting, and that's it.
In a way, but maybe not. I mean, so, you know, what we were talking about tonight is best practices.
Right.
Best practices are decisions that you make that you can control, where there are situations that you can control. There are sometimes when things happen that we can't control. So, you know, there may be a time when you hold a meeting in violation of the open meeting law, but you really need to know why you're doing it. And intentional violations aren't a good thing. The AG looks down and the court does. So the best case scenario is, do you really need a meeting under those circumstances? And if you're gonna have it, are you willing to deal with the consequences? The $1,000 isn't against a person, it's against the town. So, I mean, in theory, someone can make a donation to the town and the amount of the fine. But, as I'm sure you all know, the newspapers love that, and it's not really an ideal way to conduct business. All right, anybody else? Okay, public records. Everything made or received by a public official or employee is a public record, okay? So anything, whether it's on a cell phone, whether it's on your private email, whether it's a text message, if it relates to your public business, it's a public record. Just because you're a volunteer doesn't accept you from this rule. Public records law looks at the content of the document. So if we go back to the situation where two board members are friends, if the friends text about the Red Sox, that's not going to be a violation of the open meeting law. But if the friends text about something that's pending before the board, that would be a violation of the open meeting law. And it would also constitute a public record. So the first one wouldn't constitute a public record, text between friends, but text between members of a board on a matter involving the board, that would be a public record. I don't know if you guys remember this, a few years ago, the mayor's chief of staff deleted a bunch of emails that he had gotten from his computer at work that were personal. Do you remember this? That were personal? And the supervisor said, well, they may be personal or they may not, and we're gonna find out, so turn over your computer and we'll do a forensic examination. So just because you delete something doesn't mean it's actually deleted. Much better to copy or have someone in the loop on the town server side so that you don't have to worry about that kind of stuff. If you're using your municipal email address or if you have the specific email address, it can help eliminate questions about records retention. You can either print out all your emails related to your public position and bring them into your meetings each week, or, and I don't know what the capability is. You guys can create like a records retention email address so that if you were to schedule a meeting or something with email, you could copy that address and all the emails would be copied to that, so you wouldn't have to worry about retaining them on your home computer. Okay, requests can be made in person or over the counter. Records access officer, you guys know about this stuff? Basically, now under the public records law, it's 10 business days to respond. But the hardest thing that we find is not doing searches of employee emails that are maintained on the servers, but when a request comes in for copies of emails between board members who don't use public address or separate address and copy the town. We have 10 business days, that's it. If we don't give an estimate within 10 business days, then we don't get to assess a fee. It's much more likely, the larger the request, that it's harder to put the estimate together. You miss the 10 days, you can't assess a fee at all, okay? So you have to do that response. If you're not gonna provide all the requested records, then you have to provide a written response, and it has to list the specific exemptions and provide detailed explanations. So the records access officer can help you with that. This is the list of things that have to be in the response. I'm not even kidding. Can't even read that. I can't read that. All right. So if you respond within the 10 days with an estimate of the cost, then you have 15 additional business days once the payment has been made to do the work. So you never have to do the work before you get paid. You can always wait to get paid before you do the work, okay? The requester can grant you additional time in addition to the 15 business days, and that means that it's probably much better to talk to the requester than it is to talk to the supervisor's office. They can give an extension, but it's few and far between. So just be thoughtful that that person who's really irritating your board by coming to every meeting and asking for records at any meeting, they also have the ability to say, yeah, it's no problem, get me that, in 30 business days. It's not a rush. So, another good reason to serve the public well. Fee, so it's 5 cents a page. It used to be 20 cents a page. Otherwise, it's the actual cost. If you're ever asked for electronic records, do not take a thumb drive from someone else. It's always better to use a thumb drive from a package or one that's yours and get reimbursed for it, rather than take someone else's. The risk of hacking is huge, and it's malware. You don't want to put someone else's thumb drive into your computer. Less than 20,000 people, the first 2 hours of search time may be charged. It's the one thing that served municipalities and small municipalities in the act. The rate, so it used to be that you could charge the hourly rate of the lowest paid person capable of doing the job. And so if you had an intern in your office, you got paid, $12 an hour, then it was the $12 an hour rate. If you didn't have someone that could do that in your office, then it would be your rate. Now it's $25 an hour, period. It can never be more than that unless the supervisor says yes. Again, the requester has the ability to authorize a higher rate. We see this especially with huge requests. One city that we work with got a request for which 60,000 emails were responsive, and we determined that if we were to look at those and spend the amount of time on each one, whatever, it would basically take one regular year of work time. Clearly, the requester didn't want to wait that long, so they paid a key discovery group to do a record search, to sort things into folders, and we were able to respond within 3 months, which is what they wanted. They paid for that whole process. It was well more than $25 an hour for that. So you have the ability to negotiate that. Exemptions. So all records are considered to be public unless an exemption applies. One exemption is exemption A, and those are where a statute says that. So for a Board of Assessors, for example, statute says that applications for abatements can only be disclosed to the DOR. So that means they cannot be disclosed to anyone else. That's an exemption A. Example, Corey, the open meeting law, there's a statute that says that either you can withhold it or you can only give it to certain people, okay? Exemption C is pretty much the most common, and that's personnel or medical records. That's one category. Those are absolutely exempt from disclosure. So if it's a personnel record, and that doesn't mean how many sick days people have, it means a letter from me or a letter from the supervisor to the employee saying you're doing a great job, you're doing a terrible job, you're on suspension, you got an award, anything that has to do with personnel records like that is exempt from disclosure, and medical records. And it doesn't matter if it's an employee, anybody's medical records. So those are absolutely exempt. The second half is a balancing where the privacy rights of the record subject outweigh the public's right to know. And I'm sure that you'd be very interested to read all of the decisions on this. But essentially, I'll just try to boil down, a privacy right of a record subject outweighs the public's right to know when it's an intimate detail, highly personal in nature, like whether someone receives government aid, or whether they pay alimony, or whether their social security number or something like that. Yes?
Salary lists.
Yep, public.
Public.
Yeah. Exemption D is the deliberative process exemption. That's how you come. You can get a letter from your town attorney, or you can, your staff person can do a policy analysis and send it to you. There's policy that's being developed. It's not a public record until that policy's been decided or the matter's discussed in open session at a public meeting. Exemption E is a notebook exemption. Now this is the one exception. As long as you don't share your notes with anyone else and you're not the record keeper at the meeting, your personal notes are yours and you don't have to disclose them. However, yeah, right, someone say cool, and it's true. If you take your notebook and you look to the person next to you and you say, look at that, you've waived the exemption. So you cannot do that at a public meeting, or you have waived the exemption for your own personal notes. Okay, very important. Exemption F, records of ongoing investigations. That makes sense. If we have to disclose stuff while it's being investigated, then what good is the investigation? But also records reflecting the names and identifying details of voluntary complainants and witnesses. And the reason for that is you want people to be able to come forward, talk to the town, help it either solve crime or enforce its bylaws. So those records can be withheld indefinitely. Exemption N, I made that guy. I made him. I was so proud of myself. Infrastructure exemption under N is these two are exemptions that were passed after 9/11. The Secretary of the Commonwealth, who's in charge of the Public Records Division, and the Supervisor of Public Records were not consulted at all about these exemptions. And one of the reasons that we know this for sure is because under Exemption N, we can only disclose something if we determine that it's not likely to jeopardize public safety. So that means we have to ask a question. What do you intend to use this for? Under the Public Records Law, we don't ask any questions. It doesn't matter. Anyone can make a request for a public record, no matter what they're going to do with it. So here, we're not supposed to ask a question, but we have to make a finding that we believe it's not likely to jeopardize public safety. How do we do that? We could say things like, under the law, for me to be able to approve the disclosure of this information to you, I have to make a finding that that's not likely to jeopardize public safety. So if you were to provide me information that convinced me of that, then I can give you the records. Seems like a really hard thing to do. Mostly building inspectors get these requests. Building inspectors and also police chiefs, people often want the town's emergency response plans. No. There's a reason why we have an emergency response plan. It talks about how we're going to set up our disaster response. That's not something that has to be disclosed. And now it also relates to cybersecurity. So before that was just public, it was just infrastructure, but now it would also be information about computer systems can be withheld. Exemption O says that personal email, that's a new part, home address and home telephone number of a public employee in a public entity's records, where the records are characterized as people as such, can be withheld from disclosure. So if you have a list of employees, that list of employees' home email addresses, home addresses and home telephone numbers are not or can be withheld under the Public Records Law. If they just are, if you're also a resident and an employee and your name just shows up somewhere, it's not necessarily the case that this exemption will protect it. It's only if you're identified as a town employee. Appeals. Supervisor of Public Records, that's the appeal of choice. The supervisor makes a decision. They have now just 10 days to make a decision. It used to be unlimited. They had cases that went back 5 years that were difficult. They couldn't arrive at a conclusion. Now they have 10 days. If the applicant is dissatisfied with the supervisor's decision, they can appeal to the Superior Court. The Attorney General also has the ability to enforce. and the requester can go directly to Superior Court if they want to. So it's concurrent jurisdiction. The supervisor of public records and a court have the ability to hear it as a case of first impression. It's very, very risky to wind up in court. And the reason is that under the new public records law, again passed in the middle of the night on a Saturday, behind closed doors, if the plaintiff is successful at all after filing, the municipality has to pay the legal fees for the requester. And success for this purpose is defined as getting any record. So it creates a significant risk. It's very important to comply with the procedural requirements, those 10 days, a nice robust letter response, because if you get to the Superior Court, you want to be able to show you did everything in reliance on existing law and you complied with the law. If even if you decide you don't want to litigate and you hand the requester one of the records that they were asking for, that's considered success for purposes of this law. So, it's one thing if it's, if it's a big Boston law firm and it's $800 or $1,000 an hour, 10 hours to write a complaint, I mean, you're talking about a lot of money really quickly. And if you have to litigate it, you're talking about going into court, you're talking about discovery, so it can be really, really expensive. Which brings us to the electronic records preference I mentioned earlier. One of the benefits under the new law is you can send someone to the link on your website rather than having to provide them with a copy of the record. It's not just like, here's the website generally, you have to send them to the link for the thing they want. So if they're looking for meeting minutes from or not 19, probably, from 2010, and you have that on the website, you have to give them a link, you email it to them, but you give them a link to that 2010 catalog of minutes. There's also suggestions that annual reports be on, notice of regulations, notices of hearings, winning bids for public contracts, award of grants, minutes of open meetings, budgets, and any other information the public might want. The more that's on the website, the less you have to worry about complying with a request within the 10 days, because all you're doing is sending back an email. So what's your best practice? Use a town email account. Deliver any records created outside of town hall to town hall so you don't have to worry about keeping them. Ensure that when you hit send on an email, you're comfortable with it being forwarded, printed, posted, and tweeted. That's less of a legal issue and more of a real life issue. You have to be comfortable that that might be out there. For that reason, I always suggest using a formal tone when you're conducting town business in writing. You might know the person, you might be great friends. If you're sending out an email to your whole board, you might send it out in a very formal manner. Sometimes I disclose to the people I'm going to send to, you're going to get an email from me. It's going to say, Dear so-and-so, you have requested an opinion regarding blah, blah, blah. And they're like, I just talked to you about this 5 minutes ago, and you didn't give me that kind of an attitude. In writing, it matters differently than when you're on the phone. Avoid asking for personal information if you can. Don't ask for unlisted telephone numbers, medical information, social security numbers, financial account numbers, and the like. The less confidential information you have, the less you have to worry if you get a public records request about disclosing it inappropriately. And consider whether a formal record is required. One of my favorite, now retired town managers, whenever we get to this point in the discussion, would pound on the table with all of her employees and board members, and she'd say, people, the phone still works. And that's true. Everything doesn't need to be written down. I'm not saying that you shouldn't create records, because of course you can and you should. But there are times when you can make an inquiry by telephone that are perfectly appropriate, and that way you don't have to worry about whether you're going to get a public records request. All right.
Lauren?
Yes.
Before you move on to public hearings, just for a practical matter, if you get a public records request, if you could send it off to me or to town council before responding, because that's typically how staff does it. They're not going to respond to a public records request. They'll either forward it on Summit Records Access Officer or to town council, just so that they can review the response before it's
Yep. And there's a significant risk under the public records law, particularly if there's personal information or personal financial information, of responding without analyzing the issues first. So definitely, and also you saw all that list of things that have to be in the response if you're not getting everything. Better to let someone else take care of that. I wasn't going to do a lot about the conflict of interest law because I know it's getting late, but I will give you my 5-minute version of the conflict of interest law. And it starts with a 5-second warning. if you feel funny about something, then don't do it. Okay, under the conflict of interest law, essentially, if you think that someone else might think that you might make a decision because of a personal relationship you have, because you used to work with someone, because they're your tenant or your land, anything like that, don't participate. Okay? So if you feel uncomfortable, don't do it. That's like that feeling that you get is actually the equivalent of knowing the law. It's good enough. So that's the first thing. The second thing is, you guys as appointees to municipal boards, unless the Board of Selectmen have designated you as special municipal employees, you're all municipal employees for purposes of the conflict of interest law. Municipal employees cannot represent anyone other than the city or town in any matter in which the town, in this case, in which the town has an interest. You can represent yourself, but you can't represent your neighborhood group. You can't represent, Little League. You can't represent youth soccer. You can only represent yourself. So if you are part of an organization like that, someone else has to do the talking before town boards. Someone else has to sign agreements. Someone else needs to make the phone calls to town hall. You can't make any of them, okay? And the clerk should know who's been designated as special municipal employee boards. You can't participate in anything in which you have a financial interest, okay? A financial interest is large or small, positive or negative, and it's essentially something that's reasonably foreseeable rather than remote and speculative. Okay, if you live near something, you're in a butter to an abutter within 300 feet, or if you live directly across the street or diagonally across the street, you're considered to have a financial interest. You have to prove that you don't if you want to participate. If you have a financial interest, or if your family member, your immediate family member has a financial interest, that's essentially impugned to you. So you have a financial interest if they do. Kids, parents, siblings. So under section 19, if you're appointed, you can get an exemption, okay? So you could go to your appointing authority and say, it's true, I live across the street, but I still think I'm able to make good decisions in this case because I'm an architect and a planner and this makes sense for me to be involved. So I'm asking you, appointing authority, if you'd be willing to let me participate under those circumstances, and they have the ability to say yes, and then you can participate. If they say no, you cannot sit at the table. Participation for purposes of the conflict of interest law is sitting at the table, even if you don't speak, even if you abstain, okay? If you sit there and the discussion goes on with you there, and someone makes a complaint to the Ethics Commission, you will be found to have violated the law. Now, how do you get yourself out of being in a place like that? You just stand up and sit in the audience. And then I like to give the instruction, don't glare at anyone. Don't put your hand up 17 times. Don't applaud when people are talking. You have to act like a somewhat disinterested member of the public, okay? If other people get up to talk, then you can get up to talk. If other people ask questions, then you can ask questions. But you don't want to stand out as trying to take advantage of your position to get your position before the board. Now, the other board members also should make disclosures in that situation. If you as a board member have a conflict, your son has a financial interest in this particular matter, then all of your board members are going to look like they have conflicts because you have a conflict. So they should file a disclosure under 23B3 with their appointing authority. All that is to say, our board member, fellow board member, has a financial interest in the matter. His son is the whatever, even though we obviously value his contributions. We're going to make a decision in this case based upon the best interest of the town without regard to personal relationships. That's good enough, and now it's unreasonable to conclude that you would act or fail to act for any reason other than a proper reason. Multiple positions with the town or multiple contracts with the town can also create issues. It's very, very complicated. If you hold 2 positions with the town, one of which is paid, you should talk to town council. So, yeah, see how I did that? I don't want any hypotheticals. I don't want anyone to give me any ideas. Code of conduct, so you can't use your position to get a privilege or benefit for anyone else, which I already said. That means, I'll make a phone call for you, or, oh, you wanted to go to this thing and no one else can get tickets, but I can get you in because I know the da-da-da. You can't do that. Let's see what else. Is there anything else? Gifts. You can't take gifts for things that you've done. for or because of something you've done. If you were to get a gift, like maybe a fruit basket, you can bring it in and put it in the office, in the department office, and share it, and then it's not going to be a violation of the law. If you have a friend and the friend gives you a present and it happens to be that you're also on a board that heard something that from their, involving them, that's not prohibited by law, but you might want to make a disclosure that you have to use your kind of common sense about that. All right. Lots about gifts. Okay, I already talked about that. Acting as an agent, telephone call, writing, or signing something, or providing your seal, calling an office, appearing in person, all of those things would be inappropriate. Okay. All right, I'm not going to do that. Okay, that's it. We're done. Anybody else have any questions? You all want to go home, and I get it. So, thank you for listening.
Thank you for Lauren's presentation, and a bunch of all of these resources are going to be emailed out to everybody tomorrow. You could pass along whatever information to your boards, and I think that is it. Thank you, Lauren.
Thank you, everyone. Really appreciate it. Good questions.